My name is Masikonde, Parseen, an advocate of the High Court, and also I'll give my colleague to introduce himself.
With that kind rejoinder, my name is Stanley Dikir. I'm an advocate of the High Court of Kenya, practicing as such in the firm of Dikir and Company in Narok Town.
Thank you so much, my colleague. I would issue my statement. I was the advocate who was handling this matter, and we had a public interest litigation filed by appellants on behalf of the community. I would first go to my statement in English. Pursuant to the highly contested judgment delivered in ELC case number 21 of 2021 on the 6th of March 2025 by Honorable Justice Mbogo, the people of Narok engaged in a conversation in looking for the way forward. The way forward was an appeal, and as a result, we were instructed to file an appeal. The community, having not been party to the case in the High Court, the criteria to identify the appellants was by getting people adversely affected by the judgment. I was instructed to file a public interest appeal on behalf of the community. 3 camps, Mara Explorer Camp, Mara Intrepid Camp, and Lorian Camp that are situated on the suit property were identified as the most affected. The beneficiaries of the said camps are indeed affected by the judgment and thus qualify to be the appellants. The following appellants were proposed and provided, and I was provided with the necessary documentation. They came to my office and executed the pleadings. The first one, Tipapa Sayalel, who is the first appellant, Nderi Rakwa, the second appellant, James Somoine Tira, the third appellant, Keswe Sairowa, the fourth appellant, Charles Njonjo Loigero, the fifth appellant, and Kekanai Kirokor, the sixth appellant. Pursuant to the instructions, I filed an appeal and application for stay on the 21st of March 2025, and the same was registered as Civil Appeal number E030 of 2025. The citation is Tipapa Sayalel and 8 others versus Livingstone Kuninin Tutu and 3 others. An appeal was filed by Narok County Government, and the same was registered as Civil Appeal number E037 of 2025. A further appeal was filed by an NGO by the name Resolute Rise Community-Based Organization in the Court of Appeal in Nairobi, and the same was registered as Civil Appeal number E177 of 2025. This appeal was later transferred to Nakuru, and all the appeals were consolidated, directions issued, and the parties were to comply. It is my duty to update the public about the status of the appeals. More so, the public interest appeal that the community requested me to take it up. Immediately after filing the suit, I received a protest letter from the camps complaining that they are not interested in the appeal. I explained that they were listed because their beneficiaries were affected by the judgment. I was very surprised when 3 of my clients, James Somoine Tira, Keswe Sairowa, and Charles Njonjo, filed a notice of change of advocate and subsequent applications of withdrawal from the appeal, both dated 7th April 2025. They appointed a law firm by the name Okero, Otuomo and Company Advocate that was now representing them. On the 24th of June 2025, the first appellant, Tipa Pasayelel and Nderi Rakwa, indeed filed a notice of change. This is now the next notice of change of advocate, and subsequently filed an application for withdrawal of the application for stay and notice of appeal. The firm of JGS Law LLP Advocates was now representing them. The second withdrawal was very crucial, since the first appellant, Tipa Pasayelel, was indeed the one who saw the supporting affidavit in support of the application for stay. That being the case, and at that juncture, the public interest application for stay and the appeal stands withdrawn by the new law firm that was now representing the appellants. It is good for the public to note that there has been much intimidation and coercion against the appellants in this case from the beginning. But I had much hope that the appellants would stand their ground, which they didn't, and thus they were compromised. Further, the public should know that the county government, even though appellants in quotes did oppose the inclusion of the community in the appeal and undertook to prosecute the appeal on behalf of all the people of Narok. This is very shocking, because I thought the county government shall support the public interest appeal. This clearly meant we were not reading from the same script. There are two appeals, people satisfied with the judgment, but we were not reading from the same script. The community was very much okay to have as many appeals as possible, but the county government were fighting the community public interest appeal. On the 16th of July 2025, being the first day I was not present in court for the reasons that the appellants had filed notices of change, a very unfavorable order emanated from the hearing, from the court session in which the first respondent, Kunini Olentutu, was allowed to collect fees, levies, taxes, pending the hearing and determination of the appeal. This was the first day that Masikonde was not in court, since the notices of change of advocate were filed. The only hope that the community have is the NGO appeal, and I urge the NGO to stand firm and not be compromised like my clients. I also wish to notify the public that besides this civil appeal, there was criminal allegations against Honorable Ketuyo and Honorable Rakwa, instigated by Mulot Police Station. The same did not even reach court, and thus dismissed for being baseless. It is so shocking to see that the appellants, who were respected people in society, who were chosen with hope and belief that they shall stand firm, being compromised. These people have betrayed you, the people of Narok. But I urge the people of Narok that the community interest shall be taken care of in the NGO appeal. Thank you.